3 points.
A development in the Justice Department's probe alleging immigration obstruction in Minnesota. CBS's Nicole Skanga is covering the story.
The Justice Department today served subpoenas to multiple Democratic officials in Minnesota, Governor Tim Walz, Attorney General Keith Ellison, Minneapolis Mayor Jacob Frey, all in connection with an investigation into what they're calling an alleged conspiracy to impede federal immigration officers, according to sources familiar with the matter.
Minnesota Governor Tim Walz says, quote, Minnesota will not be intimidated into silence, and neither will I. U.S. Southern Command says U.S. forces have seized a 7th oil tanker in the Caribbean near Venezuela. Hawaii's gun laws are the focus of arguments before the Supreme Court. The justices are examining whether Hawaii may prohibit people from carrying firearms on private property that is open to the public, like restaurants and hotels, unless the owner explicitly gives permission allowing it. The plaintiffs argue that Hawaii is infringing on people's Second Amendment rights. Justice Elena Kagan responds,
This is really a property case, not a Second Amendment case. Yes, it is about guns. But the argument goes, what's really going on here is how states treat a private property owner's consent.
After 18 seasons as the head coach of the Baltimore Ravens, NFL coach John Harbaugh is officially announced as the head coach of the New York Giants. Harbaugh tells reporters,
It's a profound honor to be entrusted with the responsibility of coaching the New York Football Giants.
This is CBS News.
Welcome to Duke's Mayo Country, where the mayo is so smooth and creamy, it makes every bite better.
Do you have questions after being injured in a car accident or injured because of someone's negligence? Do you feel overwhelmed or uncertain about the next steps after being injured in a crash? The personal injury attorneys at Peronick, Caulfield, Averill, and Noyes have been helping their injured clients since 1955 and are now on this radio station to provide guidance to you. Listen to FLALAW each Tuesday from 5 to 6 p.m. Let their decades of experience help you and your family. Offices in Clearwater, non-attorney spokesman. Shenyun 2026 are coming to the Tampa Bay area February the 6th to the 8th at Mahaffey Theater, St. Petersburg. Shenyun revives 5,000 years of civilization through choreographed dance, music combining classical, Western, and Chinese instruments, and innovative 3D backdrop. Come and see it once in your lifetime. Tickets at shenyun.com/FL.
You may be owed some money. After 911 and 411, call 541. That's 727-541-1741. Call Gulfstream Motorsports for a diminished value report. Due to my 28 years experience in the auto salvage business, I'm very good with wrecks. So if your car's been involved in a wreck, call me for a diminished value report. Call 727-541-1741. You may be owed some money for the lost value of your repaired vehicle. And visit us at GulfstreamMotorsports.com.
Tune in to the Dr. Lou and Tammy Show every Wednesday, 5 p.m. to 6 p.m. on 106.1 and 102.3 FM. We shine a spotlight on local small businesses, giving them a platform and the recognition they deserve. We also dive into today's top medical news, keeping you informed and empowered. Don't miss out. Join us for engaging conversations and expert insights only on the Dr. Lou and Tammy Show.
This is Paul Porter, the arena voice of the Tampa Bay Lightning and press box voice of the Tampa Bay Buccaneers, inviting you to join me and Jason Alessi for the home team every Saturday from 9 a.m. to 11 a.m. here on the Tan Talk Radio Network and Facebook Live, the home team with Paul Porter. Special guests, prizes, and your phone calls about the Bucks, Lightning, Rays, USF, Sun, FSU, Florida, and more. Talk to you this Saturday at 9 a.m. right here on the Tan Talk Radio Network.
Hello there, Tampa Bay. This is former NFL and college football coach Jimmy Johnson. Listen to the Kelly Show every Monday starting at 5 p.m. They can sure use the attention.
And this is former Major League Baseball player, Hall of Famer Wade Boggs. I also hope you listen to the Kelly Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is marine wildlife artist and conservationist Dr. Guy Harvey. Please listen to the Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. This is attorney Matthew Noyes, and I am one of the partners at the law firm of Perinick, Caulfield, Averill, and Noyes, the personal injury law firm that proudly presents FLA Law on the radio live every Tuesday from 5 until 6 o'clock. We are here to answer your questions that you have regarding the law. If you don't have questions but you have a comment, we also welcome those as well, because really what we want to do as a thank you for trusting us for over 70 years is to be available to answer questions or discuss the law with you. So there are 3 ways you can get in touch with us today. One, it's simple. You give us a call. This is a live call-in show, so you can call us with your question or your comment regarding the law at 727-441-3000. Or you can find us on Facebook Live at Perinick, Caulfield, Averill, and Noyes Injury Lawyers. And we are there live on Facebook. It says live video is starting, so I assume that it will be going pretty soon. And you can type your comments in right there, or you can go on our YouTube channel. You can go to Perinick, Caulfield, Averill, and Noyes YouTube, and you can type in your comments there. And Mike on the other side of the glass will let us know if you have any comments that we can address here on this episode. So again, I'm Matthew Noyes, but I'm not here alone. I am here with my friend and my law partner, Lorrie Robinson. Lorrie, again, thank you for coming.
Always happy to be here.
Last time we had you on here, it was your birthday.
That's right.
So we are still celebrating you, but just your birthday plus 2 weeks.
Yes, there you go.
So Lorrie and I are here to really talk about something that happens once a year, sometimes more than once, depending on if there's special sessions. But that's the Florida legislative session. It is live and active right now up in Tallahassee. It only runs for 60 days. I wish I had a job that I only had to work 60 days a year.
We're probably fortunate it only runs 60 days.
That's probably true. But the Florida legislature session did start on January 13th, and it's supposed to end on Friday, March 13th. 2026. So Lorrie and I are going to talk about some of the laws that are being proposed and discussed in this upcoming session, or this session right now, that could become law in years to come. And so it is kind of odd how the laws are made. There's a bill that is introduced. It's either can be introduced on the House or in the Senate. And then it goes through committees and it goes through all these. I'm trying to think of my Schoolhouse Rock. I'm just a bill, just an ordinary bill. So we're going to talk about the bills that are being presented and to be discussed. There's a lot of bills out there, but we're going to focus mainly just on those that are our areas of law that we specialize in. So before we talk about the bills, Lorrie, can you say hi to the audience and let them know what kind of areas of law we do specialize in.
Yes, so Lorrie Robinson, of course, and I've been with the firm since 1998. I've been practicing even longer than that. And what we do is handle any matter involving personal injury, which would be auto accidents, slip and falls, medical malpractice. We also do Social Security disability, which is something you and I spend quite a bit of time on. And so really anything that would involve injury or illness is something that, if there's a legal process available, is probably something that we would be able to help people with. And we've been doing it for a very long time, as we celebrated the firm's 70th anniversary last year. Tampa Bay is something that we've had, Perinick and Carroll, the old Perinick Carroll, which is the root of our firm, has been helping the Tampa Bay area for as long as I've been alive.
Yes. Now we can say over 70 years. Right. We can now say that. And we started downtown Clearwater at the fire station. I think Guy and Frank Muscarella started the firm down there.
Yes, and it's always, as you've shared many times, of course, I'm a native of Clearwater, born in Morton Plant Hospital, and I always enjoy those occasions. I love being at WTAM for this reason, where we kind of, I'm going to say, get to experience just a little bit of a glimpse of the old Clearwater when it was a smaller city and had kind of a city center. I can't help but comment, I don't know, did you see the duck?
I saw that the duck was there, but we did not see the duck.
Well, the duck is quite impressive, the $30,000 duck that apparently has the distinction of being the largest duck ever. And so we have a very large duck in Coachman Park commemorating, I'm not sure what, but it was kind of cute.
My granddaughters love to hunt for ducks when they go on cruises. People hide little plastic ducks all over the cruise ship, and you go out on an adventure to try to find as many ducks as you can.
There you go. Well, that's probably why there's an interest in having the largest duck ever.
Well, and also that I did not appreciate until I went to Dollywood, and I went to Dollywood with my daughter, and there happened to be Jeep Fest up there in Pigeon Forge as well.
Sure.
And there was all kinds of Jeeps up there, but there were also all kinds of ducks. And I've come to realize, and Christine, our legal assistant, also owns a Jeep, that if you like the Jeep, you're supposed to leave a duck. And then they post all the ducks on their dashboard. So I think that the Jeeps probably liked having that big duck there as well.
Probably. So we, that's Clearwater's claim to fame at the moment. The only other thing I would add is that when I was doing a little bit of background reading for the show this afternoon, I learned 1,700 bills have been filed, maybe even a little bit more than that. And you think, so that's why I say in a certain way, 60 days is probably pretty good in one sense, because sometimes it's kind of dangerous when bills, and we're going to be talking about that, when bills get passed or even discussed for passage. The other part, though, it's a little frustrating, isn't it? That we're going to find out how difficult it is,
right?
In many instances, because there's so many different competing interests. But
right. Well, let's just jump right into the first bill then, if we can. This is a bill that's come up several times. In fact, it was passed and then vetoed by the governor. Was it last year or the year before? But that's the no-fault personal injury protection law repeal. This is Senate Bill 522. And 522. And it would repeal Florida's entire no-fault statute, getting rid of personal injury protection coverage, and instead revive the requirement to have bodily injury liability coverage. And I think the bodily injury liability coverage that they are requiring is $25,000, a minimum BI coverage of $25,000, and property damage of $10,000. Lorrie, can we re-educate our listeners and some of our new listeners who may not understand that we talk about personal injury protection as almost every show, what PIP is, the benefits, and what bodily injury liability is.
And I think it's very timely. We'll see what happens with this bill because, as you mentioned, there was an effort made, I think it was a couple of years ago, and I think it passed, but didn't Governor DeSantis, I think, vetoed it.
He did, yes.
So there are a lot of questions on both sides of these issues. But currently, and for as long as I've been practicing law, a very long time, we've had what we call the no-fault law. And the idea behind that is that if you get into an automobile accident, up to a certain level of insurance coverage, if your issues can be handled, it doesn't really matter who's at fault. So we have the personal injury protection insurance that everybody has to buy if they're driving. And that insurance will cover medical expenses up to $10,000, 80% of your reasonable medical expenses. They've added over the years a lot of difficult requirements. Now you have to have gotten treatment within 14 days of an accident. And there are other wrinkles where largely the insurance industry has kind of fought and lobbied to restrict those rights. But our situation now is if you get in an accident, your PIP insurance, doesn't matter who's at fault, your PIP insurance will take care of medical expenses within that particular limitation.
Right, but that $10,000 figure was started in the 70s.
Right, I don't think.
And nothing has changed. I mean, medical bills and medical treatment has skyrocketed since the 1970s, but that limitation is still there. I mean,
Right. And so
we see it all the time that our client can take an ambulance to the hospital, and that $10,000 is gone.
Just like that.
Just like that.
So it's very difficult, and how useful it is, particularly if you have health insurance. There's a big question about that. And frankly, that limited coverage, which you're required to have, for many people is rather expensive. It's several $100s, almost even with and that's the bare bones. But it does at least provide a mechanism where, at least in theory, you don't have to be concerned about having to go through the process of our tort system of establishing that somebody else was at fault. But it doesn't cover a lot.
Right, it doesn't cover a lot, and it doesn't cover it all either. So, as you said, it only covers 80% of the bills. So let's say you have $10,000 worth of bills. It just happens to end right there. Mm-hmm. You still owe $2,000, and the avenue to recoup that $2,000 would be to bring a litigation or a claim against the at-fault driver's insurance company. But at-fault driver's insurance company, they're required to have bodily injury liability coverage if you can make the claim. But Lorrie, is there a law that Floridians are required to have bodily injury liability coverage?
No, and that's the thing that surprises people. So, we've talked about it so many times, but people will say, oh, I had full coverage. Oh, the other driver said, oh, I've got full coverage.
Right.
But actually, all that's required is that personal injury protection medical coverage you were just talking about, and property damage liability of $10,000. So you're not even required to have a liability policy to cover you. So say I cause an accident and I don't have any liability insurance and I don't really have any ability to pay medical bills and things for somebody, you're kind of out of luck. Unless the person has assets that you could actually get a judgment against, which most people do not.
Right, and if they had the assets, they would have the insurance coverage.
Right, yeah. So, very, very limited. So, and we've talked so many times about the fact that even if people have insurance that will cover them, liability insurance, many times it will be $10,000, which is the lowest amount you can buy, and that really doesn't do too much these days.
No, it really doesn't. And so this bill that's being proposed, it would be the minimum BI coverage of $25,000, which is a start.
Right.
But $25,000 still isn't enough either in some situations. And so therefore, even if this bill passes and there's requirement to have bodily injury liability coverage, it's still very important to have another type of protection that's uninsured or underinsured motorist coverage.
Absolutely.
Can you explain that kind of coverage and who pays for that and where do you find that inside?
So that's a coverage you pay for to protect yourself and your family. So what happens, it's just an add-on to your insurance policy, but it's a very important one that protects you and any resident relative in your home in the event that somebody doesn't have any liability insurance. They cause the accident and there's no ability to make a recovery against them for your damages. But if you have an uninsured motorist coverage, which actually the law requires your insurance company when you buy your policy to tell you about it, you have to actually officially say you get liability insurance. Well, let's take this example here. If it does become law that everyone's required to have the $25,000 liability insurance. Now, they're not going to be required to have that PIP anymore under that approach. In that scenario, your insurance company is going to have to tell you about uninsured motorists. It would be an additional charge for you, but it's not that much in the scheme of things.
As long as you're a good driver.
Yeah. I mean, there could be an issue maybe if you weren't. I don't know. But for the average individual, the protection that you will receive by paying the additional premium for the uninsured motorist coverage is actually something that can't be beat. Because,
100%.
If you're involved in an accident and injured, have damages, circumstance like you're just saying a moment ago. So even with this PIP, what do you do with additional medical expenses? And if it's significant, which obviously we all hope and kind of live under sort of the nobody wants to think negatively, so you can live under the belief that nothing too bad will happen. But I hate to say that unfortunately it can happen in a microsecond. I mean, it just somebody's inattention, boom, and then you end up with a situation that it would sure be nice to have the financial capability to deal with.
And one of the problems we see is, I mean, you go to the emergency room, they do a CAT scan. We've seen CAT scans being charged at $13,000, $15,000 a CAT scan. Well, even if that CAT scan hopefully shows no internal bleeding and no significant injury, the bill is still there.
And even though, now, of course, this is one thing everybody says about these huge bills. The bills in and of themselves will be huge, but what you end up hearing often are these huge amounts, but it's still going to be thousands of dollars potentially if they run through multiple different diagnostic tests.
Sure.
And we have many, many times seen situations where that PIP coverage is exhausted or very quickly exhausted with only a little bit of coverage left over to take care, if that, for other types of your ongoing medical care versus just you go to the emergency room, which we all know how expensive that is.
Right, right. And uninsured motorist coverage is the best coverage because that's really the one coverage that you're paying for that protects you and your family.
Yes.
Too many times we meet good people after a car accident and we look at their car insurance policy. They have $100,000 worth of bodily injury liability coverage, but they rejected coverage.
Right.
Really what that means is they spent all that money to protect everybody up to $100,000 from their driving,
right,
and spent zero money to protect themselves from everybody else's bad driving.
Yeah. And it can be in that scenario too. It's like, you're saving yourself $100, $200, some small amount in the scheme of things, and you're probably a safe driver and a good driver,
right?
Because you're trying to do all the right things, and actually, in reality, you put yourself in a position of a pretty significant risk.
Right. So that's so important. Whether this law passes or not, it's still very important to have uninsured or underinsured motorist coverage.
There have been efforts being made for many years, and they did come close last time. So it's not impossible that it will, and it would be probably, in terms of the actual protection for the individual, it would definitely be better, even though the $25,000 isn't much. It's a heck of a lot better than $0 and $10,000,
right,
in many situations.
And there will be a provision for med pay as well, or medical payment coverage, and so that if you don't have health insurance or other means to pay for your medical care, and if you get involved in a car accident, if you purchase the medical payment coverage, that would pay for your medical bills as it relates to that car accident.
Right, and that's a helpful add-on. Presuming a smaller type accident, because I think it was $5,000 or something. But it
starts at $5,000.
But it still would be something that you'd have the option to do that would be helpful.
Yeah. So that is just one of the bills that we're talking about. If you have a question or a comment regarding the Florida legislature or any bills or a bill that you think should be up for discussion, Lorrie Robinson and Matt Noyes right here are here to answer your questions or to address your concerns. And you can call us at 727-441-3000. I would say jump on Facebook Live, but it still says live video is starting, and it hasn't started. So not quite sure if that's really working there on Facebook Live just yet. But I believe we are still on the YouTube channel, so you can visit Pernick, Caulfield, Averill, and Noyes on the YouTube channel, and we can address your questions and your comments there. But the best way, give us a call, 727-441-3000, and we are here until 6 o'clock live to answer your questions. But if you have a question or you say, gosh, I wanted to really look up something, what do the attorneys at Pernick, Caulfield, and Averill, Noyes think about X, Y, or Z? You can always jump on your favorite podcast platform, and you can find FLALAW on the radio and all the prior episodes posted usually a week after the live episode. And you can just jump in there and you can listen to any of the past episodes. Those episodes not only include episodes from when the attorneys at Pernick, Caulfield, Averill, and Noyes are here, but also when we have guests. Mm-hmm. Like, for example, last week I had a wonderful guest, Adam Rahman, who shared all kinds of good information about probate law and small business law. And so that episode will be posted, if not already posted, on your podcast channel. And so we encourage you that if it's not Tuesday between 5 and 6, will you still listen to us on your favorite podcast? You can go Spotify, Apple Podcasts, or any other kind of podcast platform that's out there, and I'm sure you'll be able to find us. But again, we're here, and you can call us 727-441-3000. Lorrie, we talked about the no-fault law being repealed. I assume that they think that it may not be repealed because there's another bill out there, and that's Senate Bill 926, and that's for attorney's fees and cost for PIP lawsuits.
Ah, okay.
I think that's pretty interesting because it used to be, till recently, that if you had to sue your insurance company to make them pay for the benefits that you paid for, you were entitled to attorney's fees and cost. The law changed with the PIP statute changing, and all of a sudden, the insurance companies could deny benefits, and the attorney fee provision was eliminated. So I think this is putting that prevailing parties in suits can recover attorney's fees and costs.
Right.
What are your thoughts on that?
Very, very important protection. Yeah, always sounds good if you don't really know the context. Oh, those lawyers. But in reality, what the insurance industry is attempting to do there is not just, quote, save the money of the attorney's fees. Obviously, they would want to do that. But you create a situation where fewer and fewer lawyers are even going to get involved in it.
Right.
And how is the client going to pay for it? Most people cannot pay a fee on an hourly basis very easily, and
exactly
a lot of the types of work that in our auto accident cases, that kind of thing, the contingency fee can work in that kind of a situation. But in a medical bill situation, it still would be bad. Say you had $10,000 at issue. Well, you'd have to pay a third or 40% of that to the attorney under a contingency fee. But worse yet, what if you only had a relatively small amount, which it's not small to you?
Right.
As a practical matter, you're not going to get anybody to even handle it.
Well, yeah, if the insurance company says, listen, we think that bill's too high, we're going to cut it by $200.
Right.
And the medical provider says, well, you still owe me the $200, rightfully so, because, that's what the reasonable charge is. The patient is not going to be able to find an attorney that will file a lawsuit that costs $400 in cost.
Just to file it, right.
And then pay attorney's fees just to get the $500 back. And so insurance companies have lawyers on their side, and the change of the law, which hopefully this bill changes it back, kind of levels the playing field.
Right.
And I think that's so important.
That's very important because there's so many, how many times you'd see the insurance companies, they would just decide to shave $7, $10, some small, seemingly relatively small amount from the bill. Well, there's no cost-effective manner to challenge that if you don't have the ability to require the insurance company to pay the attorney's fees if it is ruled that they are wrong.
Right.
Basically.
Yeah, it still has to be ruled that the bill was reasonable, necessary, and related to the accident. So it's not a windfall for the insured or for the patient. They still have a burden to prove their case.
Right.
But if they prove their case, they should be entitled to the attorney's fees and cost. And if it is $7 here, $10 there, well, if the insurance companies are doing that thousands and thousands and thousands of times a day, that's a lot of money that the insurance company is getting away with not paying.
And that is what they're doing, basically. So again, it should be something, obviously, as lawyers in this field, we would feel this way, but our system is set up so that you can dispute things. And when you eliminate the attorney fee provision, you're creating a situation where there's now no effective way to dispute it.
Right.
And that's not fair.
I agree 100%. If you disagree, give us a call, 727-441-3000. We would love to hear why you disagree. If you think lawyers are greedy and they make too much money, we're happy to tackle that comment or that question. Our job is to really level the playing field and make sure the insurance company pays what they're supposed to pay. Nothing more, but nothing less either. And if all we did was try to make insurance company pay more than they were responsible, we wouldn't be doing our job, and we also wouldn't be serving the clients the best that we can. We'd be losing credibility on fighting those cases that need to be fought because the insurance company is under-evaluating the claim. So give us a call, 727-441-3000. This one's also interesting, which I thought there was a law already to this effect, but after upon further research, I found that there wasn't.
Oh.
And this is Senate Bill 1152. And this has to do with bans on holding phones while driving. Right now, so this bill would make it illegal for drivers to hold a phone while operating a motor vehicle. Drivers could still use GPS, make phone calls, or use navigation apps, but only through hands-free technology such as Bluetooth and built-in vehicle systems.
Mm-hmm. Which shouldn't be that hard for people today. I mean,
shouldn't really be that hard. And so I thought that's what the law was, but that right now, the only hands-free law in Florida is in school zones. You're not allowed to be holding your phone in a school zone. That's a ticketable offense.
What about the text messaging? Because wasn't there something on that? But you're not supposed to be.
You're not allowed to have the phone at all.
In the school zone.
Oh, at all. You're not allowed to have the phone in your hand at all in the school zone. Mm-hmm. This Senate bill is going to say, not just in the school zone, but any place you can't be holding your phone. And I thought the law said, or a body part or any other body part that holds your phone, which I didn't really understand what that was. Maybe on your leg or something, I don't know. But I thought that was pretty weird that it had that language in there. But I can see why that's necessary.
Oh, sure. Right.
But it's also, if you're looking at your navigation screen or whatever it may be, you're still taking your eyes off the road, whether you're looking at your phone or whether you're looking at the screen on your dash.
Right.
You're still taking your eyes on the phone. So it's still important to be smart in using your cell phone.
And that's very difficult because, people, we are all so accustomed to doing it, basically. I'm really pretty strict on it because I feel like I cannot walk and chew gum at the same time, but I would be an exception because most people are constantly on their phone. But if you're going to do it, obviously you shouldn't be like holding it to your ear.
Right. And or looking down at it. How many times have you driven up to somebody who seems to be going slower than they're supposed to be going or moving inside their lane, saying, okay, let's pass them by and let's see if they're holding a phone in 75 to 90% of the time. Yeah. That's exactly what they're doing.
Because, as we all know, it's addictive.
It is.
It's anywhere you go. I was on the street near a friend's house earlier this morning, and the power companies out there putting new poles in. Yesterday, I think they apparently hit a water line because there was no water in my friend's house. But that got fixed. But what I noticed today, just like you see everywhere, the stance for all of us now is we've got the darn phone looking down at it, and it's just addictive. But in the car, obviously we deal with the consequences of all of that, and it's just too risky, and people need to be a lot more aware. So that's probably a good bill.
I think it's a good bill. I do think that's a good bill, and I hope that does pass. One thing what I have noticed with my son is he listens to his music through his phone. He doesn't even have XM radio or AM or FM, except for between 5 and 6 o'clock on Tuesdays, or 9 and 11 on Saturdays, so you can listen to Paul Porter's The Home Team sports radio. But he's changing the song on the phone, and I don't think you can. I don't know. I don't think you can do that by voice command. So he has to look down on his phone to change the song, and so this would prevent him from being able to do that. Which is not a bad thing either. 2 hands on the wheel. Yes. It's always the best thing, especially if it's your child and he's on your insurance policy. So it's always important to make sure that happens. So that I think is a good law, that a good bill that I hope becomes law. Another one, and Ed Davis isn't on the other side of the glass. We got Mike, but Ed always wants to talk about e-bikes and motorized bicycles and how dangerous they can be.
Right, we're seeing them so many more because it's a kind of a cost-effective way for people to be able to transport themselves and get around. Right,
yeah.
and it's so much more prevalent than it was previously.
Yeah,
but it is kind of dangerous.
Yeah, well, the Florida legislature's trying to make some changes. You know, they have, it's a House Bill 243 and Senate Bill 382, which is really the same bill. It's just both houses or both
the
chambers agreed with each other. And there's really 5 things that have to do with that. It's kind of regulation of the e-bikes. 1, they want to create a legal category called electric motorcycle, meaning an electric-powered vehicle that can go faster than 28 miles an hour. And I think there would be certain requirements that go along with that, and it's a different step up in responsibility. Also, which I think may be a good rule, but this could be a problem. If you want to ride a Class 3 e-bike, that will get you up to 28 miles an hour. You would need a valid driver's license or a learner's permit. We see a lot of younger 14, 15-year-olds, even younger, driving or riding these e-bikes. This law would prohibit them from doing that. So that could be an issue.
Right, and I can imagine there would also be a fair number of people that maybe have had issues with tickets and things, and their driver's license is suspended, or something has happened that they can't get a driver's license, but this is a mode of transportation for them. But, so this is talking about these are up to 28 miles per hour, so you're talking about the ones that really are more like a vehicle that probably should have more requirements, but I could see where there could be some questions about it.
Right. And then this one I do like, safety testing and education. Florida would require more questions about e-bike and scooter safety in the driver's license test.
Yeah.
To help drivers learn how to share the road safely. I think it should be not only for the drivers, but the question should also be written to test the e-bike and scooter operators.
Absolutely.
Of how to be safe.
Absolutely.
And really, we've talked about it in past episodes that an e-bike has the same requirements, but also the same rights as a bicyclist.
Right.
And too many people, whether it's the drivers of the vehicles or the e-bike driver themselves, don't appreciate that. You know, they think that they can go through the stop sign or they can turn left on red and such like that. And it's so important to know that the bicyclist can't do that, and so the e-bike operator can't do that as well.
There should be a lot more instruction, and maybe even like you could see I don't know what they'd have in mind with the license that's required, but you could see where something that made sure the person was competent and educated. So even a younger child, that could hopefully
like the motorcycle endorsement. I think you have to take a certain test in order to get that motorcycle endorsement. Maybe there's a license that you can have for an e-bike operator. Or a scooter. I think scooters are the slower ones, e-bikes are the faster ones, and then electric motorcycle would be even the faster one, I guess.
But I guess, and the e-bikes, I mean, the faster ones, they do drive on the roads and they're not supposed to be on the sidewalk, are they?
Well, it depends. That's the problem with the law. It's not 100% clear. If it's classified as an e-bike, they can be on the sidewalk, and that's dangerous. But they're allowed to be on the sidewalk if it's classified as the e-bike. And part of this regulation of e-bikes is also crash data and reporting. The police reports don't always record the e-bike driver or the e-bike or scooter drivers in the information. So we don't have the great statistics as to how many e-bike accidents there really are.
Which with the number that we're seeing of people operating the e-bikes now, we really should get that information.
Right, I think that's important. And then there's penalties. I haven't seen this, but I think Ed told me about this. People are deliberately modifying their e-bikes to go faster. And so this bill would put penalties for anyone who deliberately modifies the bill to make it go faster. So that bill, I like some of it. I don't like some of it. I think it needs to be looked at a little bit more and talked more to other people that may operate the bikes for different reasons. You raised a good point. Maybe they can't get a driver's license, whether because of age or whether because of other situations. Should they be prevented from being able to
use an e-bike as long as there's some way to? I mean, you should obviously be competent to handle it.
Sure.
But it would. We're a very mobile society, so if you don't have transportation, that's why these things have taken off, I think.
Right.
Because,
no, I agree. They're cheap and they're able to do it. And unfortunately, you don't need to have uninsured motorists. I mean, you don't have to have insurance at all. And so that's why uninsured motorist coverage is important, especially if you're an e-bike operator and you get hit by a car and it's the car's negligence, then you could have a claim under your family's uninsured motorist policy. So that's why it's so important to always look and see what kind of coverage you need and what kind of protection you need. If you're just tuning in, you are listening to FLA Law on the radio. My name is Matthew Noyes. Lorrie Robinson, my law partner, is right here as well. We are two attorneys at the law firm of Pernick, Caulfield, Averill, and Noyes, the personal injury law firm here in Tampa Bay, the oldest personal injury law firm in Tampa Bay. We have been helping people after car accidents, trip and falls, work accidents, and even Social Security disability claims for over 70 years. We are right here in Clearwater. Our main office is in Clearwater, but we have offices throughout Tampa Bay, and we're always able to talk with you. We can do it live in person. You're more than welcome to come to our office. We can come to you as well. Or we also can meet you by Zoom or telephone, whichever is most convenient for you. Now, in today's age, we have to be as accessible as possible.
Yes.
One good thing about our firm, which I can't say about other firms, is we are all in-house. We don't have people working outside.
That's true.
Whether
we have
it's
a headquarters, right?
Yeah, whether it's attorneys or whether it's office staff, we are all there in the house. They're able to meet with you if you have questions or comments. So if it's not Tuesday between 5 and 6, we welcome you to give our firm a call at 727-796-8282. But if you have questions regarding the law right now until 6 o'clock, you can call us at 727-441-3000, and we'll take your call live on the air and answer your questions or address your comments that you have regarding the law. Lorrie, the next bill that I wanted to talk about has to do with sovereign immunity. It can be complicated, but can you explain, Reader's Digest version of what sovereign immunity is and what the present law is?
Right. So how many times do people say, the government does this, that, or the other wrong, and or they even fail to enforce the law in some particular way that you think they should? And you think, I ought to be able to sue them over that. Nope. So we have this concept called sovereign immunity, which really goes back to the English common law, and so the sovereign, the king, it really does go back to that early understanding that there are specific laws that define when you actually can sue a government entity, the sovereign, and it limits it because it's the public purse. So it's limited but for public policy reasons. So currently in Florida, if you were injured in an automobile accident and it was a government employee working that caused the accident, you would be limited to be able to sue because the law permits you to sue for that kind of a negligence action. But you would be limited to damages at most of $200,000. Now, you could be quadriplegic, but there is a statutory limit on how much you would actually be able to recover in damages. The only way you'd ever be able to get more is very unlikely, but there are incredibly serious cases. You can go to the legislature and they can pass a special claims bill, but this is not something that happens very often. So as a practical matter, it just means that you're going to be limited, and there's a total cap of $300,000 for an entire incident. So say that it's a bus accident, and there are multiple other people that have been injured. each one $200,000 but to a maximum of a total of $300,000 for the whole claim. So it's a pretty significant limitation, but I understand that maybe they did update it. It used to be $100,000 for many, many years.
Right.
And even lower, obviously, before. And I was trying to remember, it's been probably a decade now that it's been at 200.
I think it's been about 10 years.
Something
I think
like
you're
that.
right.
I was trying to think, but
probably a little less than 10 years. But they did raise it up to 200,000. But now this bill, which in fact this bill has already passed the House, it raises the monetary cap on negligence lawsuits against governments for injuries or deaths, increases up to $500,000 per person and $1 million per incident.
Yeah.
And then they have it gradually increasing all the way up to like 2037 or something like that.
Oh, all right. Well, that's a good thing to do.
So they're foreshadowing,
Yeah.
so you don't have to keep doing it all
Right.
the time. I think it's a great avenue. Again, just because they raised the cap doesn't mean everybody gets the cap.
No,
we still
not at
have
all.
the burden to prove the negligence on the government and the negligence that is something that we are allowed to bring a lawsuit against.
Right.
I always use the scenario that if the government decided not to put a stop sign at an intersection and a deadly crash occurs, you can't bring a claim against the government. However, if they decide to put the stop sign and they fail to maintain that stop sign or the foliage around the stop sign and a death accident occurs, then you do have a right to make a claim against the government because they made that decision to put the stop sign on and then they fail to properly use reasonable care to maintain that stop sign.
Yeah, it's kind of tricky in that because people don't realize. Because if they didn't put the stop sign there they're planning level decisions. The government makes those decisions, and that is not something that you're able to sue for. But what's spelled out is you are able to sue for negligence. So if, as you say, if that decision had been made, but then they just didn't do anything to keep the stop sign up or something of that nature, and people were injured as a result of that negligence, then you would be able to recover damages. And you think about what you were saying earlier at the beginning of the show, how medical expenses, everything is so much higher today than it has been, obviously many years ago. So $500,000, $200,000 is a drop in the bucket if somebody has ended up having to go through, some neck or back surgery and has been out of work. It's so many cases will not reach that level. Fine, that's not an issue. The issue is those cases that do, where the damages exceed what has been a very low threshold amount, and so they're trying to update it consistent with what the costs are today, and that's a very positive note.
No, I agree 100%. And I still agree that the lawyer needs to prove their case, and the claimant needs to prove the case. But that's why they pay taxes, and that's why we all pay taxes, is to hold people accountable for negligence that they may have.
Right, and we would, certainly over many years have noticed that if you do not have any accountability, if nothing's going to happen as a result of failing to act carefully and reasonably, then many times people are going to let it slide.
It's going to be a snowball effect.
Yeah,
and it's just going to, chaos is going to happen. So that's why, and our job is to hold people accountable and responsible. Just like I want to be held accountable and responsible for my actions, I think it's only fair that others do the same thing. If I'm careless behind the wheel, and I cause injuries, hold me responsible. But also allow us to hold other people responsible.
And it goes back to the importance of the insurance, because many times, obviously accidents occur, maybe a person doesn't intend it, most times they don't.
Right.
But, a vehicle is a dangerous instrumentality. We know that when we get behind the wheel. So if something happens where our inattention or negligence in some other manner caused the accident, then we obviously want the party that's been injured to be compensated.
Right. I always say we help a lot of good people after bad things happen to them.
Yes.
So speaking of types of cases that we help. We also, our firm, especially Mark Perenick and Brian Caulfield, and us too, we deal with medical malpractice and wrongful death cases. And a medical malpractice is a claim that's made against a medical provider for negligence that causes injury. House Bill 6003 talks about the repeal of adult children recovery bar. It sounds like a bunch of legal words.
Because it is.
It is.
Right.
Lorrie, can you explain what the law is right now as it relates to the adult children being able to make a claim for medical negligence that results in the death of their parents?
This is one. There was a big push to get the law changed in this respect in the last session, which did not succeed. But the idea is under the Florida law for wrongful death, if you are a victim of medical malpractice, doesn't apply to any other type of negligence. But if you are if you're, let's say, your parent was a victim of medical negligence and died, if you are older than 25 years of age, as a child, you have no claim. So normally the people that if a person dies, their spouse would have a claim for obviously any economic damages, but largely the emotional distress and pain and suffering that would occur as a result of that. So for some reason, many years ago, it's been this way for as long as I can remember. Obviously children would be the most obvious beneficiaries, people that have suffered damages as a result of their parents' death. And that doesn't go away with any age, but for whatever reason, they define minor children up to the age of 25. So a child 25 or under would have the right to bring a claim or receive the benefit of a claim for pain and suffering if their parent died and there was no spouse surviving. But if you're 30 years old, or 50 years old,
or 25 and a half,
or 25 and a half.
Somehow, if you're 20,
right.
If you're 24 and 364 days, that
and
you're entitled.
Some of the kind of tough-sounding rhetoric on this, but it's kind of true, is characterizing it as the free kill.
Yeah.
So I mean, in effect, you have a situation where there's no accountability. Not in the sense of our tort system. Damage system, which is the greatest place for accountability, if you have that circumstance where there are no minor children
and no surviving spouse.
And so they're taking another run at it, which I'm glad to hear, because I think that's a great injustice. I think anybody listening knows, I mean, that the loss of a parent, particularly it's a devastating loss. So.
Yeah, and I just never could wrap my head around it that if a doctor obviously committed malpractice,
right.
Undisputedly committed malpractice, and which resulted in the death of somebody, if there's no spouse and only children that are older than 25, there's no claim. I mean, I come from a family of 11 kids. No matter what age, if that happened to one of our parents, we would be devastated, whether we're 24 or 54.
Right.
And so to have the law say, you're too old, you don't get to have pain and suffering damage for the loss of your parent for something that was clearly negligent.
Yeah, and again, the idea is accountability. I mean, I think the arguments apparently in favor of that was, damage awards and things like this. But we've had a lot of restrictions in the medical malpractice world in what's allowed and what's required over quite a number of years. And I think many people, and I think it's on both sides of the aisle, feel this is unjust and that it should be corrected.
Right.
And hopefully it will be.
Right. And there's another wrongful death bill that's pending to be discussed and possibly passed, and that's the Senate Bill 164, and that's the wrongful death of an unborn child.
Oh.
That bill would establish a cause of action for the wrongful death of an unborn child. Right now, there is no cause of action for the wrongful death of an unborn child, and so this law would make a claim for that. Now, there is an exception that if it arises from lawful medical care,
right, okay.
then it's not a wrongful death if it's lawful medical care. And I thought I read that it's also you don't have a claim against the woman carrying the child should there be a wrongful death of the unborn child. You can't bring a claim against the mother for wrongful death.
Right, and so you could envision a number of circumstances, but a child actually being the result of negligence, the death being the result of negligence of some kind.
A pregnant woman involved in a car accident loses the baby. Right now, they don't have a claim for the loss of that baby. And this law would change that.
Well, that'll be interesting. I'm sure it'll be hotly contested.
It will be hotly contested. That's for sure. That is for sure. So those are just. There's one more. The Senate Bill 1596. Since we're talking about medical malpractice, we're talking about these caps on insurances and stuff. And so there's still just another one that talks about minimum insurance coverages. And right now, doctors are only required to carry $250,000 worth of medical malpractice insurance. Senate Bill 1596 will change that from $250,000 to $1 million worth of coverage.
Should be much more realistic in our current environment.
100%.
Yeah.
100%. And there's still that's a subject for another FLA law on the radio, but there's still provisions in the medical malpractice statute that if they admit liability can still cap damages in certain ways and such.
Right.
But this minimum insurance coverage from $250,000 to $1 million, I think is something that is needed. But again, you still have to prove it. It's not, okay, there's $1 million worth of coverage, we're going to get that.
No.
Not at all. There's going to fight. You have to fight every one of these medical malpractice cases.
And the requirements that have been tightened up for many, many years now, what's required to even bring a malpractice claim it's very, 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 very difficult. So it's you're not looking at frivolous claims. You're looking at legitimate claims,
right,
and that have to be successful, going all the way through court and the jury and getting a judgment. So.
Very costly, very time-consuming.
Right.
We reject 99% of the case of medical malpractice calls that come in.
Right,
so.
And that's generally the case for lawyers because of those factors.
Lorrie, we've talked about Florida law for the past hour, hence FLA law. We talked about that. But one thing we didn't talk about in our discussions about the Florida legislature is Social Security disability. Can you tell our listeners, we got about a minute left, why there's no discussion about Social Security disability in the Florida legislature?
Sure, because Social Security disability is a federal law. So that's coming out of the federal government. Florida has no jurisdiction over any of that. So that would not be something they could impact.
Right, and so when we help all our Social Security disability applicants, we look to the federal law and Social Security Administration rules and such like that. So we need to know Florida law and Social Security law, so that's very important. You can hear the music. That means we're wrapping up another edition of FLA Law on the radio. I'm Matthew Noyes. That's Lorrie Robinson. I'll be back next week with the founder of EyeOnTampaBay.com, a very interesting Facebook page and website. So I encourage you to tune in next week. But in the meantime, I always say, drive carefully and watch out for those who don't. Take care.
WTAN, Clearwater.
FM 106.1.
WDCF, Dade City.
FM 102.3.
Listen.
This is CBS News on the Hour, your home for original reporting.